Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case Daubert versus Merrell Dow Pharmaceuticals. This case was heard in the Supreme Court of the United States in the year 1993. Let's go ahead and jump into the facts of the case. So there's two plaintiffs in this case. They're children that were born with birth defects. And the mothers, when they were pregnant with these children, took a drug called bendectin. Bendectin was supposed to help women with morning sickness during their pregnancy, nausea and vomiting. And both these women took that drug, bendectin, that was manufactured by Merrell Dow Pharmaceuticals. And these women are saying, they're arguing, they're suing Merrell Dow, saying, Merrell Dow, your drug bendectin caused our children's birth defects, and we ought to recover for that. So that's what the whole case is about. Now, you can't just say that and recover. You've got to, show some proof in a lawsuit. And so because we're dealing with a scientific topic, you're going to need to show some expert testimony on the topic to prove that bendectin, yes, it was the cause of your children's birth defects. So that's what the court's grappling about. This is a case about evidence, and it's a case about expert testimony and what's the admissibility of expert testimony, especially on scientific matters. The district court, had this question before it. You had the defendants who brought in one expert that was going to testify. This expert was well credentialed. He reviewed many studies and basically came to the conclusion that bendectin did not cause birth defects. Birth defects occur in the general population, but bendectin was not, an increase of those birth defects. These kids just would have had birth defects whether it was mothers had taken bendectin or not. So that was what the defendant's experts said. The plaintiffs had 8 experts, also well qualified, one from the state of California, that are arguing, bendectin did cause these birth defects, and we have some studies to prove it. We have some animal studies, we have some embryo studies, we have unpeer-reviewed human studies that haven't really been subjected to publication or peer review, but we have them. And we want to put these before the jury to show that, bendectin did cause these birth defects. Well, district court says, no, we're not going to let the plaintiff's experts in. This isn't generally accepted scientific knowledge, that we can allow it before the jury. We don't want the jury to make some confused assessment about this scientific knowledge, allow the plaintiffs to recover when bendectin wasn't really the cause of the birth defects. So where did this general acceptance language come from? Well, it came from a case called Frye versus United States, where the D.C. Circuit Court of Appeals said that if you're going to introduce expert testimony and they're going to testify about science, that science needs to be generally accepted within a scientific community. What does that mean? Probably peer review, probably publication, some type of replication. What you would think of when you think of the scientific method and what you might have learned in grade school. So that's Frye. And the Ninth Circuit Court of Appeals said, yeah, district court, you did a nice job. It's tough. These plaintiffs aren't going to be able to recover, but their science was squishy. It's not based upon the scientific method. It's not generally accepted. And so Frye is going to rule, and Frye says, we're not going to let these experts in. What does the Supreme Court say? Well, Supreme Court says, sorry, Ninth Circuit and District Court, you got it wrong, okay? First, we're going to start with the fact that the country enacted, and I say the country because the judiciary was involved and Congress was involved, with enacting the rules of evidence. And these rules of evidence supersede the common law that was in effect before the rules of evidence. So this Frye case, this general acceptance test for scientific knowledge, came down in 1923. Well, that's a long time ago, okay? And so Frye doesn't govern anymore explicitly, right? Because we have these rules of evidence that superseded Frye. So they say, based on Frye, yeah, it probably would have failed, but Frye doesn't govern. The rules of evidence govern. And so the court then walks through the rules of evidence that would apply here. And Rule 402 is basically just relevance. And it says if evidence is relevant to a case, then it's going to be admissible. And they say, well, okay, so this is relevant. But then there's also another control over that, which is Rule 702. And that's really the meat of this case, is Rule 702. What does that mean when we're going to allow experts into court to testify about scientific matters? What does Rule 702 really mean? Can anyone come in? Do they need to be a super expert? Do they need to have thousands of articles that they've have been peer reviewed that they're basing their opinion off of? Can they base their opinion off of 2 articles? What does that look like? And that's what the court is trying to do in this case. So the court says, yeah, this really is about reliability of scientific knowledge. and the qualifications of the expert, right? And so the court doesn't really provide a bright line rule here. They provide kind of a flexible 5-factor standard. And so this is the Daubert standard, and is what you'll hear. So first, was the science tested? And can it be tested in accordance with the traditional scientific method, what you've learned in grade school? 2, has the scientific study been subjected to peer review and publication? Okay, this seems like a big one. The court does say it's not the sine qua non, so it's not essential to accepted scientific knowledge, but this is fairly important. 3, what's the error rate of the study? 4, are there standards controlling these studies? And then 5, is it accepted by a widespread scientific community? So these 5 factors are going to guide a court's inquiry when they're determining whether or not they should admit an expert to discuss some type of scientific matter. And the court says, why is this important? Why do we need to have this control over expert testimony? It's because experts are allowed to testify about things that they don't have first-hand knowledge about, right? Normally there would be these other rules where you have to have first-hand knowledge if you're going to testify in court, and the experts don't have that rule. So experts need a little bit more controls. They need a little bit more boundaries placed upon them before we let them in and talk to the court about science, right? So that's essentially the case. I think is a very interesting case to think about. One, what is there a difference between legal truth and scientific truth? And should there be? Should there be a higher standard in legal truth, or should there be a higher standard in scientific truth? What is truth really? I mean, that's a very kind of just existential question. What is truth? And if we do have truth, should we have different definitions for different arenas, the legal arena and the scientific arena? I think there might be an argument that says, yeah, we should. Maybe legal truth is not quite as high as scientific truth. I think the idea behind science is that we don't really know truth ever. And will we ever be able to attain or reach that truth? And I think science is constantly grasping for that. But, science is constantly subject to revision, which shows that we didn't have the truth before that. But, in the legal arena, we need to make decisions. That's the sad reality of it. We have timelines and decisions that need to be made, and they might be fallible, right? And we might not be able to get the perfect answer in a court case because science might evolve over hundreds and thousands of years before we know what the proper answer was. So that's just really a meta kind of philosophical question to think about, but it really is what's got to be guiding the court here. If you're thinking about how do I really think about this case, it's a fight over what's legal truth and what's scientific truth. And the court basically says, well, district court judges, use your discretion and find what you can. Look into these experts and see if you think it's going to be reliable before you're going to present them to the jury and before you're going to allow the jury to be swayed by these people. And so that's kind of the brunt of the case. I think it's also good to know that whether or not a judge admits expert testimony is subject to abuse of discretion standards. So this really does make district court judges kind of kings of the case, if you will, especially when it comes to evidence, right? Because it's going to be tough to overrule a district court judge for them excluding scientific evidence. We put that control into the hands of the district court judges. They're called judges. We respect their judgment, and we expect them to do a good job in doing so. So that's the case. Really interesting questions to think about. I hope you enjoyed the video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.